Hey, welcome back. This is Shah. Today I want to talk about no-fault divorce, and I want to discuss the changes that happen between traditional fault-based divorces and no-fault divorce. I think this is valuable to discuss because I think a lot of people don't really understand how marriage used to be in the United States. And, I see so much shame thrown around with people who either don't want to get married or they were married and they get divorced. And especially for men too, a lot of the blame goes our way. And it's just like, you weren't man enough to hold this marriage together and things like that. And I think it's a little unfair because no fault divorce is relatively new. It had huge changes to the contract of marriage. The marriage of our grandfather's time, the quote unquote real men, was completely different and had a lot more protections for men and even for both parties to some extent. What I want to do in this video is discuss the history of marriage, at least in the United States, and how it changed over time. And to do that, I found two papers that provide a pretty good history for us. So we'll take a look at those. The first one is called No-Fault Divorce Legislation and Its Impact on State Divorce Rates. That was published in 1981. The second one is The Direction of Divorce Reform in California, From Fault to No Fault, and Back Again. And that was done, I believe, in 97. This is the history section of the first paper I mentioned. And at first, I didn't want to go this far back because this has taken us all the way to the English colonies and all this stuff. But frankly, I find it fascinating. And I think if we go this far back, you'll get a better handle on where our marriage laws are kind of rooted in and how it evolved. So I'm going to read a few paragraphs. Chapter 1, History of Divorce Reform, Church versus State. Divorce reform in America began with the English colonists. As settlers in a new land, they brought with them a body of well-established divorce procedures as sanctioned and implemented by the Church of England. However, separation of church and state was a fundamental issue for many who came to America and was quickly achieved in matters relating to marriage. In England, as elsewhere in the Western world, marriage had been under complete church control since the 13th century AD. Only ceremonies performed by church officials were valid. The bond they created between two persons was considered sacred and indissoluble. Divorce was not permitted. Consequently, there were no grounds for marital dissolution. The church did provide alternatives to a failed marriage, however, recognizing the sinful nature of man even within the sacred institution of marriage. In certain cases, an annulment could be obtained, which declared the marriage invalid from the outset and freed individuals to marry other persons if they so chose. Impotency, disparity of worship, defect of consent, and consanguinity were among causes deemed sufficient to declare a marriage null and void. So this is interesting because way back then, divorce wasn't even allowed. At least, in England and all the English colonies, which included the U.S. And the reasons they give to annul a marriage, so that's like saying legally the marriage never really happened. It was never supposed to happen. Was impotency, so if there's infertility going on, disparity of worship, I guess that would mean if someone's not really Christian in that sense, or, I don't know, maybe they're a Satan worshiper, so it wasn't going to work out. Defect of consent, maybe one or the other party didn't give consent to the marriage in the first place. And consanguinity, which means that you guys are probably related and have a similar ancestor. So that's interesting. So, back then, in the age of the realest men ever, they really didn't have to worry about this because it was, divorces were not going to happen. Under other circumstances, many of which later formed the basis for legal grounds of absolute divorce, adultery, insanity, a form of legal separation known as divorce from bed and board, divortium a mensa e toro, resulted in spouses living separate and apart but being unable to marry again because the marital bond between them remained intact. On rare occasion, a very wealthy and influential individual received a divorce by private act, obtainable only from Parliament or the king. Records indicate that between 1800 and 1836, there was an average of 3 such divorces granted per year. Wow, so that's interesting. So the only people who actually could get a divorce were probably noblemen to begin with, and you had to have enough pull to where the entire House of Lords or whatever needed to hear this, and then the king needed to make a decision. It's very Game of Thrones. With this exception, divorce was unavailable under ecclesiastical law. England was, legally speaking, a divorceless society. In the absence of legal recourse, desertion and adultery were frequent accompaniments of marital breakdown. The ecclesiastical stronghold was broken from the outset in some of the northern colonies. Ideologically, their sentiments ran parallel to those expressed by Luther during the Protestant Reformation. Declaring marriage to be a normal human institution, he repudiated the sacramental character of marriage as a priestly invention, and the exclusive control of the church as an unwarranted usurpation. Unlike Luther, the colonists were successful in translating their beliefs into action, and in some areas, authority was transferred out of the hands of the church and into secular channels. Civil contract theory, which dominated attitudes toward marriage and divorce prior to the early centuries of the Christian era, was once again at the forefront of the colonies. Following the American Revolution and the end to English domination, most of the states, including those in the South, claimed and exercised a legislative prerogative to grant divorce by private act. At this point, authority had passed out of the hands of the church and into the state legislatures. In most cases, however, divorce remained available only by private act, special permission of the governing body. Gradually, the states undertook further reform measures as the number of divorces increased and the legislative process came under attack as being cumbersome, arbitrary, costly, and lacking in procedural safeguards. So what's interesting about that last part is, this is talking about the change from no divorce to actually being able to have divorce that's controlled more so by civil procedure in the courts versus the churches. And they're dealing with this issue of costliness and an increased rate of divorce. But what you're going to see again, what happens is around the 60s, and here in the United States, we're seeing people bringing their divorces to the court. They're trying to get divorced, but it's tough because first they got to find grounds to do that since there's no fault. But the courts are also just not made to handle this many divorce requests. And then to get divorced, it usually required a lot more of the court's time because someone has to prove fault. There might be a trial, all these kinds of things. So they were looking for reform, not even just in these times to change it from annulment to regular divorce, but also in our times to change it from fault-based to no fault. So it's a recurring pattern. Based partially and on the already operative New England model, virtually all the states enacted legislation granting jurisdiction to the civil courts and enumerating specific allowable grounds for divorce, thus creating a legal matter out of a moral issue. One notable exception was the state of South Carolina, where the introduction of divorce laws was expressly forbidden by the state constitution. The other states varied in the laxity of their laws, from New York, where adultery became the sole ground, to states having a variety of recognized causes for divorce. These grounds continue to change from time to time through legislative reform. Within states and across states, additional grounds were added, existing grounds were deleted, or both. What we're seeing here is the gradual evolution of divorce law. And, way back when, marriage and divorce was in the domain of the church, and they regulated a lot of that stuff. And for the most part, divorce was not going to happen. For, the newly birthed America and its peoples, that was just a little too much, and they were not having that. So that's how we kind of got into our fault-based divorce system to begin with. So that's pretty interesting. Now, what I'm going to do, let's jump over to the other paper, and that's going to explain a little bit about what constituted grounds for a fault-based divorce. Many American states enacted divorce legislation soon after independence. In the 1780s and 1790s, Connecticut was the most liberal, permitting divorce for adultery, fraudulent contract, desertion for 3 years, or prolonged absence with a presumption of death. In 1843, the state added 2 additional grounds for divorce: habitual drunkenness and intolerable cruelty. So that looks like it starts to cover some of like what could be considered domestic abuse, domestic violence right there. The Connecticut state legislature also dissolved marriages on other grounds by legislative action. In 1849, the courts were given sole responsibility for divorce, and grounds were extended to include life imprisonment, any infamous crime involving a violation of the conjugal duty, and, most important, any such misconduct as permanently destroys the happiness of the petitioner and defeats the purpose of the marriage relation. Divorce laws were generally more liberal in the West than in the rest of the country. California's first divorce law in 1851 contained the following grounds for divorce: impotence, adultery, extreme cruelty, desertion or neglect, habitual intemperance, fraud, and conviction for a felony. In practice, the courts extended the definitions of these terms. So to me, what's really interesting about this is that, I'm looking at this from a guy's point of view and signing a marriage contract with someone, and we hear a lot of nightmare stories about guy gets married, gets cheated on. It's not his kid. He still has to pay child support because the kid's over 2. He has to pay a ton of spousal support. I mean, we're looking at something similar with Tyrese Gibson. We always see the stories, right? And I saw plenty of them myself working at the child support agency, where my job was to, go after the money from these folks. And, it's this huge change between these grounds for divorce and someone just being able, like one party being able to walk in there and just saying, hey, it's not working out and I want a divorce. Another thing that this paper has that I really like is a really helpful table. Let's look at this. So this is table 1, summary of changes in divorce law. And on the left side, you can see we got traditional divorce. And then on the right side, we got no-fault divorce. So this helps to kind of explain the major differences. In one sense, we got traditional divorce being a restrictive law versus no-fault divorce being a permissive law. And what that means is, the divorce laws were initially crafted not to help people get divorced, but more so to help families stay together. Like, there was definite they made it hard because they wanted to keep family stability as a priority, believing that the family unit was ultimately what made up society, and that the breakdown of the familial unit would lead to the breakdown of society. Okay, so it was more restrictive versus no fault, which is something that's really designed to facilitate divorce. Specific grounds versus no grounds. So that included some of the stuff we talked about, right? This includes adultery, cruelty, imprisonment, insanity, all that kind of stuff versus no grounds. So no fault divorce is saying, hey, we don't care if the husband cheated. We don't care if the wife cheated. We're not looking at that stuff. It doesn't really have a bearing in how we're going to process this divorce. Moral framework versus an administrative framework, right? So guilt versus innocence, and neither responsible. So why this is important, it's not just about everyone being like, oh my God, this person did this thing. And I have a picture from my private investigator of her walking out of his house really late at night, and we know what was going on there. It's a moral framework because any breaches of morality now have an impact on how the judge awards certain things from the marriage, which could include the marital property, the house, alimony, child support, custody, right? So what we go from is a system where if you're a guy and you're the provider and you're paying for everything and you're married to someone, wife doesn't work or she makes comparatively little, and she cheats on you, you would not have to fear divorce as much, because if you can prove the cheating in court, the judges are compelled to take this into account in their discretion and say, well, since you are the injured party and she is the cause of the injury, you maybe get first dibs on custody. You get to keep most of the marital properties and assets. Alimony is going to be impacted. Maybe she doesn't get that much. It's not just, one-sided for the gender. I mean, it does work in the other way, right? Like, if the husband goes out and cheated and the wife brought evidence of that to court, she would then keep most of the assets. She would get the first dibs on custody and all that stuff. And then because she would be the injured party. So in that way, it did provide more protections than the contract we have today. Because what happens now is no matter who does what, the judges just split it 50-50. And if you're the higher earner, you're paying spousal, you're paying child. Custody's a whole separate problem. You know what I mean? Most of the time, the ladies get it. You can get it, but, you have to go in there and fight for it. It is really tough, especially when the child's really young. So, and that brings us down here. Financial awards linked to fault. Financial awards based on equality and need. And so what this chart says is, for the traditional side, alimony for innocent, quote unquote, spouse, great share of property to innocent spouse. On the other side, for no fault, it says alimony based on need, property divided equally, right? So, the way it's sold and presented is on equality, and that alimony is based on need. But the way this really translates, because what we see, the majority of people paying alimony, spousal, and child support is men. And that's typically because women are going to want to marry a man who's, a higher earner and a provider in that sense. And what we see now is a lot more women working, but typically, like, they're not going to want to marry a guy that's making less than them, right? So it looks good as equality, and but the problem is on the ground, most of the time men are shooting themselves in the foot because they're marrying a woman who doesn't work or doesn't have a career like them. So then no matter what happens in the marriage, when the divorce finally comes, the person who's in need is the person who makes less money, right? Or is not working. So it's always the one with the money that then has to pay. Adversarial versus non-adversarial. One party guilty, one innocent. Financial gain in proving fault. See, that part is really important. Versus the other side where there's no guilty or innocent party and no financial gain from charges. Amicable resolution encouraged. So let's go ahead and just take a look at the other paper again. And just read a little bit more, and then we'll discuss more about impacts. So let's start at the bottom here. No-fault divorce laws provide for the dissolution of a marriage upon a finding by the court that the marriage has broken down to the extent that any reconciliation is unlikely. The premise of fault is eliminated. It is not necessary to show evidence of marital misconduct. The focus of the inquiry is the condition of the marriage relationship rather than the acts and characteristics of the partners involved. Either spouse may file for dissolution using the neutral format in regards the marriage of John and Mary Doe rather than the familiar John Doe versus Mary Doe. If it is determined that the marriage is not viable, regardless of reason, it is dissolved. Generally, the courts accept as conclusive evidence of marital breakdown the statement of one or both of the spouses that the marriage has failed. So see, you only need one person to say, hey, this is over. There doesn't need to be any mutual desire there. In some states, counseling or an interim period before actual dissolution may be required or may be recommended at the discretion of the court. The no-fault divorce procedure is a dramatic change from the traditional adversary approach in which an innocent spouse is granted a divorce from the guilty spouse upon proof of marital wrongdoing. Prior to the no-fault laws, mutual desire and consent were not legitimate grounds for divorce. So this is important to know, right? Because it's different than it is now. There's an innocent spouse and a guilty spouse. And if you were the innocent spouse, the way the judge divided assets or, property of the marriage and all these things was going to be more in favor of the innocent spouse than the guilty party who caused the injury, right? When it changes to no fault, this goes away. The other part that's interesting is that there needed to be mutual desire and consent. And if two people wanted to get divorced, unless there was some kind of somebody injured the other party, the courts really weren't going to grant it. So somebody had to do something wrong. One of the things that we do need to acknowledge is that fault-based divorce did have issues for society that kind of caused this change to no fault in the first place. So it's hard to lobby for going back to fault-based divorces unless you solve these particular problems. But let's read this next passage together. Problems associated with abuse of the traditional divorce process are widespread and well known. The fault system is attacked as being hypocritical on the grounds that it not only tolerates perjury and collusion, but actually encourages such actions. Couples who do not have legally acceptable grounds for divorce, but who wish to terminate their marriage, frequently fabricate evidence and perjure themselves in court. Such action is commonplace, and Wheeler states that most people in the legal profession accept as axiomatic the notion that perjury is the rule in divorce courts. The fact that everyone is involved, including the couples and their lawyers and the judges, results in a sham in the courtroom and contributes to disrespect for the legal processes. So what you're seeing here is people who want to get divorced, right? And what this paper was ultimately looking for is no fault divorce the reason the rate for divorce went higher? Is there a causal link? It ultimately says no. What it says is that people were wanting to get divorced, but the law was just preventing it. You know what I mean? So, and people were already, lying to get around the law. So the divorce rate was steadily increasing. And no fault kind of just caught the law up, so we didn't have to lie in court in order to do that. That issue, and then the issue of bogging down the courts with these really long, legal proceedings that need to take place in order to get the divorce, it just wasn't really looked at as efficient. Costs were high, and you can only imagine, what as expensive as divorce attorneys are now, getting a divorce like this would be really expensive. But at the same time, guys do spend a lot of money on divorces now. I mean, there's all kinds of stuff that happens, and you hear about these divorces where thousands of dollars really get spent anyway. So would it be cheaper? I don't know. I really, would it be more expensive? Maybe not. I don't know if that's a great argument against it. The reason I think it's so important to go over this stuff is because we're in a time now where the marriage contract is just way different than it was before. And a lot of times culture holds us, especially men, to the same standard that it always has. You know what I mean? With the importance of marriage really sold in a way that's more often spiritual, more often moral. But the protections that used to be there, not only just for men, also for women too, aren't really there anymore. You know what I mean? So it's like, you as a guy who's successful, it's a really tough decision to get married, and most guys are kind of, a lot of guys are checking out. I don't know about most, but a lot of people who've been through a divorce once also are kind of reluctant to want to get married again now because they don't want what happened to them once to happen to them again. And in my time, I working at the child support agency, I saw so many cases, where guys got cheated on, the kid wasn't theirs, they're still ordered to pay. They're just getting, taken through the ringer, and they all just were unaware of how the divorce laws worked, how the child support laws worked. And I saw so many guys that were just like, if I can go back, I definitely would not have signed the marriage paperwork because it locked him into so much. But before, what we have now, our forefathers were playing a completely different game than we're playing now. So, when you hear the kind of proverbial boomer sort of language, like, guys don't want to get married anymore, this and that, it's breaking down. I mean, it's also a little bit because they kind of, punched us in the gut with these law changes. And now that women are making more money, I mean, a lot of this applies to them. The only marriages that I saw that where the divorces were amicable and seemed to be, balanced, with parties more often than not saying, hey, what's yours is yours, what's mine, it's mine, let's just split this down the middle because we each contributed to it anyways, was parties where both the mom and the dad, husband and wife are making about the same amount of money. If you're making about the same amount of money, divorce shouldn't be as scary. And marriage isn't as scary if you're making way less money. Hey, if I met that nice nurse lady who's making 10 to 15 grand a month, I'm about to be putting all the charms on her, and I will sign that marriage contract so fast. But you see, that's messed up. You know what I mean? Because I know that she then has the sword of Damocles above her. And if I am abusive towards her or just cheat on her and do all these things, when the divorce finally happens, you know, she's going to have to swallow that pill a bit and put out some of that money, right? And that's what most guys have been dealing with for a long time. So I just wanted to discuss this and provide a little bit of the history of what divorce looked like, because first of all, it's important for guys to understand that and know what they're dealing with so that they can make a more informed decision. Second of all, I also want to just get rid of that sort of shame and guilt a lot of guys feel because they look at their forefathers and they're like, they were able to do it. Why wasn't I able to do it? Am I not man enough or something? You know, at the end of the day, you're taking a way bigger gamble, especially if you're going to get married in the traditional sense where wife is stay at home, you're protector, provider, right? And you just got to understand that the way the game is designed now, it's just way different. It's a way different risk, you know, analysis here. And it's like, you know, when I think of any business contract, right? Like whether it's a licensing deal, I've read contracts like this where one company and another company are doing business. You know, there are so many different like breach of contract laws and punishments and things that are going to happen if one party doesn't fulfill their end of the bargain, right? When you get married to someone, you know, people want to get married because it's solidifying their commitment, but you're committing to something, right? You're committing to upholding something. And with that, if there are breaches of those commitments, then there should also be punishments and consequences. As we see it now, I mean, it's not really the case. You can do a breach of contract. And like, you know, if you're the stay-at-home, you know, maybe I'm a stay-at-home dad, she's earning the big bucks, and, you know, I go out and cheat on her or something like that, I still get to leave with 50-50, you know, and, you know, I might even be primary custody of the kids at that point because I've been staying home taking care of them, you know, and she's got to work during the day, so that's tough. And then she's paying me spousal and child support. I mean, that's the future for a lot of women, you know, especially as ladies start to make a lot more money. They might start thinking twice about these laws also. But the other question we need to answer is, well, what do we do? Can we just go back to at fault? We see Texas. I think there was news with Texas trying to do that, maybe Nebraska. But then you're going to encounter a lot of the same problems you had where couples are colluding with the lawyers and judges in order to lie to get their divorce. You know, and the courts being backed up with that. I think what we can do is take some of these protections that traditional fault-based divorce gave us and encode that into the laws we have now. Now, like, we can still leave irreconcilable differences in there. We can still leave no fault there, but, you know, I think we can add some language to laws that help give a little bit of these protections, because then when it comes to you can get the divorce if you want to leave, but when it comes to the divvying of the assets and the financial aspect, I think breach of contract should play a bigger role. You know, so if someone cheats, someone does something, you know, abusive, cruelty and stuff like that, you know, maybe someone's a victim of domestic violence, then, you know, they can get that divorce and that restraining order and still be able to retain, you know, custody and these kinds of things. So it's a troubled topic. A lot of the advice going around now is to just not sign the paperwork. Maybe just do a religious marriage. I don't know if that's feasible for a lot of people. I think a lot of, at least for Christians, the folks who officiate the marriage, typically, I think part of that is also signing the marriage certificate, which is tied in with the state. Other religions are a little bit different, you know, where you don't need that. So I don't know if that's viable, especially for that group of people. But a lot of people, you know, are thinking maybe it's just better not sign the paperwork. And anyways, yeah, let me know what you think down below. Hit the like button, hit the subscribe button, and we'll see you on the next one.